For over 3 years, I've been prevented from any contact with my children. I've been under constant protective surveillance by U.S. Marshals, and my entire life has been destroyed financially. I've lost my dignity. I've lost most of my friends, I guess if they were my friends, because people think I'm lying or crazy, deluded, when I talk about being a federal witness in a racketeering case. People think there's no way that the Department of Justice would put you under protective surveillance just for testifying about a couple dirty Chicago judges and your money laundering ex-husband. And they're probably right, because this case is about a lot more than a few dirty divorce judges. My testimony and the crimes that have impacted me touch on the very highest level of elected office in Illinois, including Congresswoman Jan Schakowsky, Senator Dick Durbin, and Federal Judge Jorge Alonso. So in this video, I explain how my messed up, insane divorce case has thrown me into one of the biggest racketeering cases in recent history. It is really hard to prosecute municipal corruption cases, especially cases targeting judges. It's very hard to find a reason to bring in the FBI and other federal investigators, which is why I believe my family is important to this case. We bring two things: federal questions and predicate acts. You need both under federal RICO law to issue wiretaps and to conduct an investigation over the years, as has been done in my case. First, there's my ex-husband. He's a German national named Peter Matt, here on a green card. And as a green card holder, he automatically raises federal questions about immigration law, especially every time he defrauds a court. Add to that his tendency to engage in white-collar crimes such as tax evasion, money laundering, and wire fraud. These bring predicate acts, which is what you need to open up a RICO case and let the FBI into the court. Then there's me and my children, the main victims. During most of the serious crimes that I'm going to discuss in this case, I was a FINRA licensed vice president of wealth management at an investment bank, which brings FINRA a federal question. But also, I was sitting in Chicago while trading client securities on exchanges located in the Southern District of New York in Manhattan. This means that I would imagine there would be a basis to prosecute this case in the Southern District of New York, which is known for conducting sophisticated white-collar criminal cases, and unlike the Northern District of Illinois, is untouched by the Cook County machine. Add to this is our son, who is developmentally disabled and covered by the Americans with Disabilities Act. Because of his disabilities, he is also covered by many entitlement programs. And where there is an entitlement program and a white-collar criminal father, white-collar entitlement fraud is certain to follow, conducted in this court and in federal programs. What this means is, when I say that I'm a racketeering victim in residence, it's not because I'm super special or because I'm under a psychotic delusion that I have been chosen by the Lord and Savior to be a victim. It's just pragmatic. My family brings a lot of federal questions and gives a basis for federal prosecutors to go after more and more judges. So that's why I've been stuck in this case for 3 years. My ex-husband could have easily been arrested 3 years ago when I became a federal whistleblower and provided testimony about his white-collar crimes. But that would stop the wiretaps. That would stop collecting more criminals. That would stop this case. So I'm hoping that by sharing this video, I can stop it, because I'm tired of having my dignity, my finances, and most importantly, my children taken from me in order to bust dirty judges. I've given enough time, I've made enough sacrifices, and I want out. I know a lot about federal racketeering law because I came to eventually file my own civil RICO case. I tried every court I could access to try to put a stop to this insanity. And One of the things that's required in a RICO case, besides interstate commerce interference and predicate acts, is leaders of the racketeering enterprise. There are two leaders in this case. The nominal leader, Presiding Judge Grace Dickler, who headed the Domestic Relations Division of the Circuit Court of Cook County during the time all these crimes I mentioned were committed. And I can assure you, Judge Dickler knew about every single act of fraud, every single crime, every single violation of judicial ethics, and did nothing to stop the criminal enterprise, and used her authority to shield the criminals. Now, in addition to the face of the court, there has also traditionally always been a political patron running things behind the scenes. For decades, the person who picked judges, was the kingmaker in the Domestic Relations Division, was a man named David Pasulka, a guardian ad litem, or GAL, who could decide who got to be a divorce judge, who got to be a guardian ad litem, and because of this power was able to broker children. He used this power to rape mothers by threatening to take their children away and taking their children away when they refused him. And he also raped an associate at his law firm. This was all reported in 2017. Judge Dickler, the Illinois Bar, were happy to keep him in his role for another 3 years until he was finally arrested in 2020. Pasulka was replaced in the role of behind-the-scenes political patron by his law partner, a GAL and former judge, son of a former prominent judge, named Michael Bender. And Michael Bender, in 2019, was illegally appointed as my children's guardian ad litem, and is still in that role. Every aspect of this case was run or approved by Michael Bender, and every aspect of this case was witnessed and shielded and understood by Presiding Judge Grace Dickler. Grace Dickler abruptly retired in the fall of 2022, and it was reported in the press that there was no explanation for her abruptly leaving office, but I'm pretty sure I know why. And I'll get to that. So how does a dim-witted former judge like Michael Bender or a drunk like David Pasulka come to wield so much power in divorce courts in Chicago? Well, like everything in Chicago politics, you have to start with the machine. Chicago is a one-party town. It happens to be the party that I usually vote for as a liberal, the Democratic Party. But in any one-party system, there's going to be a tendency towards political patronage and corruption. Because only Democrats win in Chicago, that means that anyone who gets the endorsement of the Democratic Party to run for circuit court judge in Cook County is going to win. The real election happens before the general election, even before the public primary election, in the proverbial smoke-filled rooms where the power brokers in the Cook County Democratic Party decides who gets to be a judge. This includes national office holders like senators and congresspeople, powerful donors, and powerful people within the Cook County Democratic Party. Now, the reason that somebody like Michael Bender or David Pasulka is important to the Cook County machine is, unlike elected officials, guardian ad litems are attorneys. That means they're in private practice, and their bank accounts, their business holdings are not a matter of public record, unlike a judge or other public office holder. That means it's really hard to bribe a judge or a senator or a congressperson, other than campaign finance, in 2022. But it's pretty easy to bribe an attorney. In fact, attorneys can be trustees, sit on boards, and have any number of blind, hidden positions within financial vehicles with which to transfer assets. So if you find a corrupt parent, like my ex-husband Peter Matt, who is willing to pay for child custody, and you find a corrupt GAL like Michael Bender, it's relatively easy for Peter to transfer his hidden assets in Europe to Michael Bender. Michael Bender can in turn funnel money back to the Cook County machine and the candidates there through campaign donations and other means. And he can also tell them who is going to be a candidate. Part of this is pragmatic. If you're a senator or a congressperson, you're not going to know every would-be judge in your district. So you're going to look for somebody to tell you who to endorse. And Michael Bender, before him David Pasulka, and Grace Dickler could always tell the machine who to endorse. And the endorsement means you get to be a judge. Because all of the associate judges who are appointed temporarily and all the family law attorneys know that Michael Bender can deliver the lucrative circuit court judgeship, which is worth millions of dollars in salary and pensions, they will do anything that Michael Bender tells them to. That way, when Michael Bender tells an associate judge, like Judge Robert Johnson assigned to my case, to give full custody to the father, Peter Matt, who bribed him, without any basis or any evidence supported at any trial, Judge Johnson is happy to do that because a circuit court judgeship is worth millions of dollars in salary and pensions. And that kind of evil is another reason, I would imagine, that I've been subjected to years of these crimes while federal prosecutors make their case. What I would eventually come to learn is that the Cook County machine is so powerful that it also impacts the reviewing courts. An astonishing number of judges that I encountered in higher courts, again, I tried screaming about the crimes at every court in Illinois, an astonishing number came out of the Domestic Relations Division. And what I learned is that because the appellate court judges, the Supreme Court judges, the new circuit court judges on the bench are all given their jobs by the machine and their money by the machine, they know not to go after circuit court judges. So no matter what crimes, no matter what brazen violation of judicial ethics might be reported to them, the reviewing courts are going to make sure that these cases are never heard, that these judges are never embarrassed, and certainly that these judges are never prosecuted or risk losing their jobs for their crimes and malfeasance. So how does my ex-husband, Peter Matt, just some German guy, know how to find a dirty Chicago judge to bribe for child custody? Well, you start with a dirty lawyer. I first met Peter's dirty lawyer, Steve Klein, in October 2016. At that time, I thought we were working on a collaborative divorce. I had left Peter the summer before, and he blindsided me with an attempt to get a restraining order on our bank accounts. I was absolutely dumbfounded because at this point I knew Peter was hiding millions of dollars in assets in India and Europe. And I couldn't imagine that somebody who is a financial criminal would want to file a financial motion in court. I was shocked, and I was just certain that somebody in the circuit court or the judge at that hearing or reviewing court would send Peter to jail for being a financial criminal and bringing this evidence to court. Because I made it very clear in my testimony to Steve Klein and to the judge at this first hearing that Peter was a tax evading financial criminal. And I just thought it was a matter of time before some grown-up at the court would put a stop to his nonsense. I didn't think that a lower court would think it was a good idea to flout federal financial law. And I was terribly mistaken. So in another weird coincidence, I know that Steve Klein is the kind of lawyer that people who like to organize the outcome of cases would hire. In a really bizarre coincidence, in 2019, I started dating a former trader who told me that he wanted me to know, because I might have found it myself, that a couple decades earlier, his name and full-page picture of him had been in the Chicago Tribune because he was a gambler and he was also a racehorse owner, and allegedly he liked to bet on horse races where he knew the outcome, and allegedly he had engaged in organized activities with other people whose names I never heard, never wanted to hear, and that these organized activities had let him know how the horse races would end. And I knew that somebody who liked to know the outcome of horse races would also like to know the outcome of divorce cases. And at this time, he was finalizing his divorce. So I asked him who his divorce lawyer was, and it was Steve Klein. I'm not saying that Steve Klein is involved in organized crime. I'm just saying that Steve Klein uh, is a shady bastard. But nobody has seen or heard from Steve Klein since I became a federal whistleblower in January 2022. His name has appeared on filings, but he's been out of sight. And instead, his junior partner has been the face of the case. Looking back, I never thought Chris Werman, his junior partner, matched Steve Klein. Steve Klein is red-faced and belligerent, the epitome of old-style Chicago sleaze. Chris Werman was very clean-cut, athletic, polite, smarter, classier. And after Steve Klein disappeared, something strange happened. I had brought to the attention of senior management at their firm, Swanson Martin Bell, that all of the evidence about Steve Klein's participation and complicity in acts of fraud, furtherance of Peter's financial crimes. And within a month of me becoming a whistleblower, Steve Klein and his junior partner, Chris Werman, abruptly left SMB. And they joined a new firm called KGW Chicago with an office address located in the Wrigley building. The only issue being that neither the firm KGW Chicago or their office listed in the Wrigley building ever existed. I know because I went there, and it officed a company called Oil Dry that had never shared office space with an attorney and had never heard of Chris Werman or Steve Klein. After I became a federal whistleblower, at first I was really shocked because, again, Chris Werman had always seemed smarter than, say, Michael Bender or other people involved in this case, smarter than my ex-husband. But suddenly he kept filing things that had nothing to do with family law and seemed to be either retaliation against me for my testimony or other predicate acts in a RICO case. At this time, I was researching racketeering law because I was trying to file my first civil rights case. Later on, I would realize I don't think Chris Werman was stupid. I think that the fact that he was building a racketeering case around me wasn't an accident, and I hadn't discovered it. It was being built around me by Chris Werman and the people he was cooperating with in federal investigative offices to build a RICO case. At the same time, the fraudulent contempt allegation was being trumped up while Brad was throwing my case. Somebody had gone into the court's filing system, the office of the clerk, and changed my mailing address from 423 Linden Avenue in Wilmette to 423 Linda Avenue in Chicago, a non-existent address. So I was actually mailed 3 postcards letting me know about the hearings they were hiding from me, but they were returned to the clerk, addressee not found. And I spoke to the clerk and asked if there was some sort of computer error that had caused it, and she said, "No, you changed it." And I said, "I did not change it." And I said, "I'm me, so what email did I use to change it? And what ISP address is associated with the change?" And she said, "I can't tell you that." And I said, "But I'm me." And it was sort of a who's on who, and I never got to find out. And in a funny, Chicago funny way, the fraudulent address, last I heard, is still the address on file at the office of the clerk. I've written letters, I've spoken to supervisors, I've tried to contact everyone to try to get the fraudulent address changed. But of course nobody can change it because that would be to admit that the fraud happened. So somebody changed it, I assume Brad Trowbridge or somebody working with him, using an email address and claiming to be me. So that was another way that the court hearings were hidden from me. I learned all about this fraud in the spring of 2021. And the reason I started digging into the docket was because I had decided to finally test Judge Johnson. I knew Michael Bender was dirty because you just have to have maybe a 2-minute conversation with the man to realize he is confused, shady, icky, and corrupt. It's not hard to figure out. I don't know how people trust him with their secrets and their money, but they do. But I really wanted to think that Judge Johnson was just naive, being misled by a senior, an older man who was a former judge. I didn't want to believe he was actually corrupt, because I didn't want to think everyone was corrupt, because it sounds fucking crazy. So I tested him. I knew that since there's no record of most of what happens at hearings, and things that I would say to Michael Bender were either forgotten or hidden, that the only way that I could get the truth on the docket was to file my own petitions or motions. I called it leaving breadcrumbs for democracy. I just had an intuition that at some point the truth of the fraud that I was unraveling would matter, and in real time I needed to document that. So I decided to file a slurry of petitions to Judge Johnson, making it impossible for him to deny that he knew about Peter's financial crimes and neglectful and dangerous parenting practices. So I filed my own contempt allegations, and I also filed a financial allocation motion, where I not only stated that Peter is a financial criminal, I provided at least 5 bank statements with numbers, foreign addresses, financial statements, foreign tax filings, showing at least 3 businesses that Peter controlled in Europe and India and hid from the IRS and the court while claiming poverty. He still does this. This is why I was ordered to pay child support in the amount of $2,000 a month, which is why I'm homeless now. So anyway, at this point, I still wanted to think that Judge Johnson could be redeemed. Maybe he'd be mad at me for embarrassing him, but surely he wouldn't want to back a criminal. So I brought him the evidence of Peter's extensive, obvious financial crimes. And I also brought him evidence of Peter's endangerment of our children. He had given them lead poisoning. A doctor found this from unpermitted constructions. He had built 3 unpermitted apartments in his single-family home without any added fire escapes or any measures to add safety while turning it into essentially a tenement. He had put ads on websites advertising these apartments, and all the boarders were random men. He refused to perform background checks, and he refused to provide locks on our children's living areas, including their bedrooms. So in other words, he is completely reckless and incompetent when it comes to parenting. And Judge Johnson knew this. But as I would come to learn, judges have this special way of protecting the reputation of the criminals they are protecting. Instead of ruling on the motions, they just delay it forever. So he said, these sound like very serious allegations. I'll give them to Mr. Bender. And if he thinks something is with merit, we'll have a hearing. And of course, there was never a hearing. So it was when I realized that Judge Johnson was actually crooked that I started digging into things. And I discovered Brad Trowbridge's fraud, the fact that he didn't file an appearance and purposely didn't have Michael Bender removed. But I still didn't understand why Brad Trowbridge would do this. It's really hard to bribe someone in a modern banking system. And I know that my ex-husband is cheap, and Brad committed serious felonies, so I didn't understand what he could be getting. I knew that Michael Bender could give him referrals as a family law attorney, and Brad also was working as a custody supervisor, but a few referrals for a felony didn't seem like a fair trade. But then in 2022, I realized why Brad Trowbridge threw my case when he became Judge Trowbridge. So in exchange for throwing my child custody case and committing many acts of fraud, lawyer Brad Trowbridge became Judge Brad Trowbridge. So how does this unremarkable attorney working out of a shared office building in Lakeview come to get a prominent role as a circuit court judge? He didn't teach college classes. He didn't even have a receptionist, much less a large firm. He didn't write papers. And in fact, I would come to learn that Brad Trowbridge had tried to run for judge in the spring of 2020. But running in the primary as a down-at-heel divorce attorney, he got no endorsements and got nowhere. But then in 2022, he ran again. And after defrauding me at the behest of party leader Michael Bender, he got an endorsement list that included the who's who of Chicago Democrats. The one who stood out most to me was Congresswoman Jan Schakowsky. She stood out because she was my congresswoman, 30 minutes north of Brad in the North Shore suburb of Evanston. And I was curious why somebody like Congresswoman Schakowsky would give her endorsement to Brad Trowbridge, how their paths would meet. And I asked Congresswoman Schakowsky many times why she endorsed him, and she refused to answer me, although she did put me on her campaign fundraising email list. So I think it's almost impossible that Congresswoman Schakowsky doesn't know Michael Bender. I'm certain that Michael Bender told Congresswoman Schakowsky to give Brad Trowbridge the endorsement in exchange for throwing my case. Michael Bender lives in the town right next to Jan Schakowsky, and they're both prominent leaders in the Democratic Party. But in addition to geography, party, and Brad Trowbridge, I've seen some other connections between the two. In the fall of 2023, I was still able to see my children for a brief period, but I was ordered to see them while paying a custody supervisor $250 an hour. And I had to see a custody supervisor from an approved list of providers prepared by Michael Bender. The first name on the list was the first one I called, and it was a nonprofit called Appner-Gar. And they stood out to me because Appner-Gar informed me they only work with South Asian families, and my family's not of South Asian descent. And I thought, gosh, Michael Bender must really like Appner-Gar to put him on the list. But then a few months later, I was following Jan Schakowsky's Instagram, and I noticed that she was giving government checks to Appner-Gar. She's a supporter of this nonprofit. And I happen to think that it would be interesting to see where the funds are going out of Appner-Gar. There are a lot of public Instagram posts of handing big checks to Appner-Gar, but I have a feeling that the checks coming out of Appner-Gar are not going to be posted on Instagram. Now, Appner-Gar is a nonprofit dedicated to domestic violence victims, partners, and their children. And I have no doubt that many, if not the majority of the employees there, are sincere advocates of domestic violence victims. But it is also true that predators like Michael Bender and Brad Trowbridge hide behind the veneer of issues like domestic violence in order to hide their crimes. And it is also true that it is impossible to support abuse victims while taking money and political power from people like Michael Bender who sell children to abusive parents. That's why I very much want to see every dollar going into and out of Appner-Gar, and very much want to see every dollar going into and out of Congresswoman Jan Schakowsky's war chest. And as for my fraudulent address with the Office of the Clerk, it was not changed by Clerk Iris Martinez, and such fraud had occurred under her predecessor, Dorothy Brown. In fact, I would come to learn that Dorothy Brown's office was under FBI surveillance for 3 years, and she was personally a target for 3 years prior to being forced out of office in 2020. One of the concerns, allegedly, that the FBI had about Dorothy Brown was irregularities in the clerk's e-filing software system. I can attest to that. But there are also direct connections to the Office of the Clerk in the fraud in my case. Namely, Kay Mason, an employee of the Office of the Clerk who works as Judge Johnson's clerk. Kay Mason has been a facilitator and active participant in every aspect of the frauds that I've discussed here. In 2021, yet another costly appointee was added to our case, something called a parenting coordinator named Dr. John Palin, a psychiatrist. Dr. Palin, I was told, had the job of deciding parenting decisions in our children's best interest. And shortly after being appointed, he accidentally copied me on an ex parte email. It was an ongoing thread. There were emails before that I was not copied on between Dr. Palin, Judge Johnson, Peter's attorneys, and GAL Michael Bender. And the content of the email was even weirder because Dr. Palin wrote, "I want to be paid. It is as simple as that." And at that time, Dr. Palin had a positive retainer balance. He had no legitimate basis to ask for payment. So I believe, and believed then that it was solicitation of bribery. Now, after learning about this email, I asked everyone in the thread to show me the rest of the emails, and they refused. And Judge Johnson has acknowledged that there are more emails, but I don't need to see them. And he has said that, and he has threatened me with being found in contempt of court for trying to subpoena the ex parte email thread from his clerk, Kay Mason, and other people. I think it's probably a law in every state that you aren't allowed to have ex parte communications. But in Illinois, the rule is that you're supposed to disclose the content of the communication as soon as possible. So legally, I'm supposed to see the rest of the emails, but Judge Johnson refuses. In addition to appearing to solicit bribery, Dr. Palin has been an active participant in my ex-husband Peter Matt's financial crimes. In one of his especially ludicrous schemes, Peter called a meeting with Dr. Palin, and the purpose was to get Dr. Palin to stop me from interfering in his business plan, which was to have our developmentally disabled 13-year-old named CEO of his company so he could defraud other businesses into contracts for companies owned by disabled people. And at Dr. Palin's request, he put all of this in a business plan, including his plan to actually keep all of the shares in our son's name, keep control of the shares, money, and to keep all of the salary reported as paid to our son as part of the fraud. Because for somebody to be CEO of a company and get disabled-owned company certification, they have to have a majority share in the business and make the most money. But of course, Peter only wanted to commit a fraud. He didn't actually want to give our son ownership. And instead of saying, hey, Peter, don't use your disabled child to defraud other businesses, he said, I think that's a great idea. Sounds like a great activity for your son, and barred me from interfering. And as with all of these other asinine shenanigans by Peter, everything is known by Judge Grace Dickler, everything is known by Judge Robert Johnson, everything is known by every judge who's ever touched this case in Illinois, and they all refuse to protect my son. So now I'm going to talk about some of the really weird stuff. I haven't talked about it to anyone privately, much less online, because it's so weird it makes me sound crazy. But that ship has sailed, so I might as well tell the whole truth. So first of all, there was yet another appointment in the fake custody case. Dr. Johnson appointed Dr. Gerald Blackman, a psychologist, as a custody evaluator in the summer of 2021. And even though there was no custody case started and our parenting plan had been entered, in a custody case, a custody evaluator writes a report recommending any changes to custody. So we had to pay him $8,000, and he conducted a bunch of psychological tests, which he would later deny conducting. And I think it's probably because my ex-husband, Peter, I don't think he has the capacity to fake his way into acting like he's honest and engages in pro-social behaviors and understands fit parenting. He's not that level of criminal. But Dr. Blackman conducted the tests and pretended he didn't. And he also hid reports by our children of child abuse, reports by our children's pediatrician of child abuse by Peter. And most disturbingly, he hid the fact that my younger son had repeatedly said that he wanted to kill himself, and the reason was he didn't want to go to his dad's anymore. Like many people in the case, Dr. Blackman disappeared after I became a whistleblower. He hasn't been seen from since. But a month after I became a whistleblower in January 2022, in February 2022, Michael Bender's associate prepared a letter to the court, an unsigned letter attributed to Dr. Blackman, which was called a preliminary custody evaluation, which doesn't exist under Illinois law. but it was a letter, and the body of the letter was a recording of my testimony at a substitution trial, an SOJ trial, to try to get Judge Johnson removed. So it was my testimony about the fraudulent hearings, my testimony about Judge Johnson's ex parte email thread about bribery. It was my testimony about everything I've said here. Obviously, it has nothing to do with parenting, and obviously it was testimony under oath, subject to perjury, but not something that you're supposed to be able to use against me. But Dr. Blackman argued that my truthful testimony about crimes was a basis to take away my parenting rights. And this letter was the only evidence that's ever been submitted to take away my parenting rights. So anyway, after this letter was submitted, and after I was trying to sue everyone in federal court, I didn't think I could win a federal lawsuit. I just wanted to get an injunction. And I was trying to serve Dr. Blackman in July of 2022. And when I went to his office in the early afternoon, I found his office dark and empty, and prominently wedged into his door at eye level was a card from a federal contractor telling Dr. Blackman to call him. And it was, in addition to serving him the lawsuit, I really needed to see Dr. Blackman because Judge Johnson had ordered me to see him or be found in contempt of court. So I couldn't track him down, so I called the Naperville police and had them do a welfare check so I could prove that I was trying to not be in contempt of court. And so the police officer went to his house, and Dr. Blackman said he was fine, but his criminal defense attorney had advised him not to have any contact with me. So after that, Dr. Blackman was replaced, and Judge Johnson ordered Dr. Michael Flynn, a new custody evaluator. But at the same time, Judge Johnson had rubber-stamped protection orders prepared by Christopher Werman on Peter's behalf. There was no evidence for the protection orders. There were no trials. But Judge Johnson issued a 3-year plenary order protection, so I couldn't have any contact with my children for 3 years. So I didn't really see the urgency of meeting with Dr. Flynn, and I didn't have any money to pay him. So I didn't. When I lost my children, I really thought somebody would care. You know, I thought I could get a journalist or the ACLU or somebody to care, because I had always cared about civil rights, and I thought people would care about mine. And, you know, I read stories every day about real criminals, rapists, murderers, terrorists, and there are countless lobbying groups, pro bono attorneys who are treating their civil rights as precious as gold. But as a mother who just wants to mother her children, and my disabled son whose only friend is his mom, and my younger son who has been locked in his room and hit for not doing well enough on tests or in soccer games and just wants to be with his mom, there's nobody advocating for us. I've learned that over and over again. So I was trying desperately, emailing every investigative journalist I could find, every legal advocacy group, and eventually I would start to meet other moms in family courts across the country who were in similar positions. I mean, Chicago's a little extra good at corruption, if I do say so myself. I mean, Louisiana might give us a run for our money, but I think we're still better. But, and I got a lot of contact eventually from real moms, but I also got contact from not real moms. So in the fall of 2022, when I was reeling from losing my children, I started getting calls on my work phone from a woman calling herself Danielle Carrillo. And right from the start, I really didn't believe Danielle Carrillo was who she said she was. She was just a little too eager, mirrored me a little too closely. She, similar age, similar style, boy mom. She was a hockey mom. I was a soccer mom. And I thought I had seen her before outside my then boyfriend's apartment in Lincoln Park. I She looked like a dog walker I'd seen who seemed a little too interested in me. I know that sounds crazy, but just wait. It gets a lot weirder. So Danielle Carrillo was calling me, and I called her back, and she wanted to talk on Signal. She would claim that she was getting a bunch of us moms from Chicago together to talk to a journalist. And at that point, I was already skeptical. So I was like, great, have the journalist talk to me. I'll tell him my story. But of course, there was no journalist. She was just trying to entice me into a relationship with her so I could tell her things and, most importantly, be told things by her and controlled by her. Yeah, it sounds crazy, but like I said, just wait. So first of all, Danielle Carrillo knew Dr. Flynn, the new custody evaluator. She said that she had been ordered to see him and that he had given her a questionnaire that said she had to answer on the computer, I use cocaine daily, I use cocaine weekly, or I use cocaine occasionally. And she said, I don't use cocaine. And he said that she allegedly, Dr. Flynn told her she needed to put something, or he would tell the court she refused to cooperate and she wouldn't see her kids at all. So I was kind of glad I didn't have the money for Dr. Flynn. But she also claimed to know Michael Bender. And this is where I especially got suspicious. She said that she had seen him at the Fontainebleau Hotel when she happened to be there. And even as she said this, I knew that on my Instagram reels, I have a reel that's Michael Bender's Tinder profile. And I know that one of the pictures in his Tinder profile is him in a cabana in Miami Beach. I never looked at it closely, but I imagined, oh, it's probably the Fontainebleau. And sure enough, after I talked to her, I zoomed in and it was the Fontainebleau. But Danielle Carrillo claimed that she was at the Fontainebleau and happened to run into Michael Bender and he saw her ogling a 13-year-old girl. I don't believe Danielle Carrillo was really there or really a mom, but I do believe the woman talking to me was in a position to know what Michael Bender likes to look at, the kind of young lady he likes to look at online. And I think she wanted me to know that he's a pedophile so that, allegedly, so that I would maybe be more tolerant of being forced into a RICO case targeting him over the last 3 years. She also claimed that she had heard that years ago an attorney was looking into Michael Bender and was murdered. I couldn't find any evidence of this. I don't think that's true, but I do think the woman talking to me wanted me to feel like I was potentially in danger and maybe be open to having U.S. Marshals around me all the time so that I would be safer. I'm not. I'm not open to that. In addition to Danielle Carrillo, there were other fake moms. Later in the summer of 2023, one of them told me that she had heard that the associate attorney who was raped by David Pasulka, the first Dirty GAL, that it was actually Molly Caesar, who is Michael Bender's current law partner. It's Molly Caesar law firm that I've been ordered to pay tens of thousands of dollars, and which has helped to force me into bankruptcy because orders to pay a guardian ad litem are considered child support, and you can't discharge them in a bankruptcy. So I think that it's probably true that Molly Caesar was the attorney who was raped by David Pasulka. And I think the woman talking to me wanted me to go easy on Molly Caesar because Molly Caesar's cooperating. And that didn't work because I didn't rape Molly Caesar. I just know I've been ordered to pay her tens of thousands of dollars. And until that stops, I don't intend to go easy on anybody on this case. According to the Federal Witness Protection Act, federal witnesses who are placed under protective surveillance by U.S. Marshals or in the Witness Protection Program, they have to give consent. So that's one of the weirder things about me claiming to be under constant protective surveillance by marshals. It's true. Nobody believes me. I have been institutionalized for saying the truth about it, but I haven't left my house in the last 3 years without at least 10 marshals following me. And that's not counting the constant airplanes and the Danielle Carrillos and others online. The only explanation I can come up with is that most of the people who are in federal witness protection are cooperating witnesses. They're criminals. And they have criminal defense attorneys who negotiate before they provide their testimony. I gave up the goods before ever talking to anybody about what I could get in return. I gave my testimony, 300 pages of it, under affidavit in a federal court, which could easily be read to a grand jury without getting my permission or giving me any consideration. So that's part of it. But it's also because of my nature and the way I approach things, I accidentally have helped exponentially broaden this case and prosecute it. I'm somebody who believes in systems. I'm a system thinker. I believe in logic. I believe in facts. So I literally interpret laws. And I've always just stupidly and naively assumed that the rule of law would trump cronyism and relationships in Chicago. I just thought I just have to get it to the right judge and the right court, and everything will be cleaned up. And in order to do this, I kind of knew this from owning businesses where when you read HR books, it's all about federal law, and it's about not crossing the live wire of federal law, right? Protected classes of employees, for example. So I knew that, or I thought I knew, that if I just stood in front of a new judge and screamed, "Look at me testifying about federal crimes, you wouldn't dare do anything to me," that they wouldn't dare. But when you do that and they do dare retaliate against you, that just broadens a racketeering case. That's the only way I can think of to explain how I found myself in this situation that nobody believes I'm in. But I also think at some point, federal prosecutors realized that I was going to keep pushing to every court I could access and get in front of every judge I could find. And so I believe that they influenced which judges I went in front of because of potential targets that they've been eyeing perhaps for years. So the first step when I realized that Judge Johnson was dirty was to try to get a substitution of judge, or SOJ. And in the Circuit Court of Cook County, as most courts, the assignment of judges is supposed to be random. I don't think it was random that my case was assigned to the relatively new Circuit Court Judge Matthew Link. Judge Link had come to the bench after 10 years as an attorney for the city of Chicago, but he had lost that job recently because the man he worked for, Ed Burke, was convicted of bribery. I suspect that somebody like Matthew Link, who is very polished and smart and slick and escaped getting caught by the people investigating Ed Burke, I suspect that maybe those people still wanted to go after him. So that's why I don't think it was a coincidence that he was roped into my racketeering case. And needless to say, the Honorable Matthew Link did not find that Judge Johnson holding secret ex parte email threads demonstrated bias. He did not find that Judge Johnson holding secret hearings that were hidden from me demonstrated bias. And of course, I was thrown right back into the lion's den. So after I'd burned through my options at the circuit court, I was just certain I'd get relief at the appellate court. I know that Chicago is about relationships, and I figured the appellate court wouldn't like to smack the hand of a circuit court judge. But unlike a civil trial in circuit court, all of the appeals court decisions are very public and highly scrutinized. Where there's oral arguments, there's going to be a transcript, unlike in any of my hearings, except for maybe the first hearing. And so I just knew that I would get relief at the appellate level. What I didn't understand is that to protect the judges, a woman named Sharon Oden Johnson, an alumnus of the Circuit Court Domestic Relations Division. You can guess how she got her job and what her job was to do at the appellate court. In her role, she plays whack-a-mole and makes sure that anyone trying to file an appeal like me is denied hearing, so that our complaints and our testimony about crimes by judges are never put on the record to embarrass those judges or her, or to cut off the cash supply that goes to the party and her. But before that happened, I had to get through constant interference from the offices of the clerk of the circuit court and the clerk of the appellate court. First, the clerk of the circuit court just didn't send the record on appeal, even though I requested it in a timely manner. For some reason, one of the employees was actually ethical and called me up and explained that she should have gotten the request to send the record 2 weeks before, but for some reason it was set on her desk that day, the day of the deadline. But she got the record transferred, and so my record was at the appellate court, and you need the record on appeal to write your appellate brief. So I waited for the appellate court to send me the record, and Matt Irvin, the employee there who prepares the record, sent me a record for an entirely different case. And then after much back and forth, Matt Irvin finally sent me the correct record. The next time I tried to appeal, the record from the circuit court went through because I'd found the names of the supervisors and the people involved with it, and I tightly managed that process. But then the appellate court just didn't send me the record. So I went downtown and I went up to the office of the clerk of the appellate court, and I said, can I just have a printed copy? Because I hadn't gotten the email. And they said, oh, we can't, because Matt Irvin, the person who prepares the record, he's still working on it and he's out to lunch. I said, that's okay, I'll wait. So I waited, and Matt Irvin came and he said, oh, I'm so sorry. The record has been corrupted. And I said, oh my goodness, the circuit court sent you a corrupted file and you docketed it? Because it was on the docket. And he said, oh no, it was not corrupted when I docketed it, but now it's corrupted and I'm waiting for tech support. And I just, you won't be able to get the record until tech support comes. And I said, well, that's an easy problem to solve. You can just call Gretchen over at the circuit court and have her send you a new record, because you said the one you received wasn't corrupted. So Matt Irvin went back to his office, and wouldn't you know it, the bug was fixed, and he sent me the record. But it didn't matter, because, as I started to say, Sharon Oden Johnson sits on the appellate court to make sure every attempt to appeal that would embarrass the criminals at the circuit court is denied. And her basis repeatedly was that my appeal was untimely. I appealed the motion to substitute the judge, the SOJ, which is a separate action from an underlying case and should be appealable, but she said it was interlocutory, which means the other case had to be wrapped up. She denied my right to appeal the plenary order of protection, which is definitely a separate case from any underlying case, because she said that was related to an ongoing case and I had to wait for that case to wrap up. And the third one, which was related to an ongoing case, was a motion to reconsider the contempt ruling because Judge Johnson had defrauded me to do it. But here's where it turns into a dystopian clusterfuck, because Sharon Oden Johnson was arguing my case had to end before I could appeal, before I could have access to the relief of the appellate court. The problem is my case never started. The only case that I was involved in the Domestic Relations Division, ended in September 2017, when I entered into a divorce and parenting plan that were approved by the court. Even though there have been countless appointees, there have been motions, there have been hearings, there hasn't been a new case started since. An example would be a motion to modify the parenting plan. There should have been a case before Michael Bender and others were appointed. Their appointments were illegal, but no case ever started. And what does that mean? That means that Michael Bender was appointed in 2019 to write a report for a case that never existed, so it can never end. And that's why 6 years later, he still hasn't written his report. He's still billing me because the case never started. The case never started, so it can never end. That's what I mean by a dystopian clusterfuck. And any judge, if a layperson can figure that, an esteemed judge like Sharon Oden Johnson can also figure that out looking at the case record, that this is a trumped up case in order to get kickbacks and screw over a woman, me, and my children. But Sharon Oden Johnson didn't get her prestigious position at the appellate court for practicing actual justice. She got it for paying fealty to the Cook County machine. and paying back the people who put her in office. And that's what she's doing. I don't know if the corruption case my family's embroiled in is dragging on because federal prosecutors want more judges at the circuit court, or people like Matt Irvin and Sharon Oden Johnson at the appellate court, or if it's because they're after even bigger targets. As I mentioned, when I was desperate to find any kind of relief to get out of this corrupt court, I filed my own federal civil lawsuit. I didn't know how, but I knew my civil rights were being violated, so I went to the Skokie Law Library and read case law to try to figure out how to file a lawsuit. I wasn't arrogant enough to think I could win a suit. I just thought I could get a federal injunction to get me out of the court. I just wanted the crimes to stop. I wanted my children back, I wanted my ex-husband arrested, and I wanted to stop being the victim of crimes. After reading cases, I realized I had what's called a color of law suit, which basically means that under color of state law, using their authority, someone has abused my civil rights or committed a crime against me, which is usually framed as a civil rights violation in these suits. And I knew that was happening because judges were using their power to participate in money laundering and tax evasion by hiding Peter's crimes, which constituted conspiracy, that they were probably participating in bribery, that they were definitely engaging in acts of retaliation against a witness over and over and over and over again. I had been found in contempt of court for my testimony about their crimes. So while I was reading the suits, I also discovered something else. Most of the suits, I couldn't find any where people were suing judges because it's impossible to sue judges. But again, I didn't need to successfully sue the judges. I just needed an injunction. Or I even believed that I just needed them to retain counsel, because under the Illinois Code of Judicial Ethics, you can't be a judge over somebody for whom you have more than a de minimis interest. Or specifically, you can't be a judge in a suit where one of the parties is in a lawsuit with you. So since I was suing Judge Johnson and he had retained counsel, he was obviously in a lawsuit with me. So he should have recused himself. He didn't, because he has no problem violating the law and judicial ethics, because if anything you've learned in this presentation, the laws don't apply to Chicago judges. So I didn't know this. I was still naively a believer in the law, even in Illinois. So I tried to file suit, and I also discovered that since there weren't cases about judges, I was reading a lot of cases about police brutality, because there are a lot of color of lawsuits about police and sheriff departments, etc. And I noticed something interesting in one of these suits. In addition to a color of law suit, I think it's like section 1942 or something, the attorneys had made a claim, a civil claim, under the Civil Racketeering and Corrupt Influencers Act, otherwise known as RICO. And as soon as I read that, something clicked, because I was like, wow, that's the law you use to go after the mob. And the Chicago court system is like the mob. And so I started reading about RICO, and I was just stunned because my case fit so neatly into the RICO playbook. I couldn't believe how lucky I was. Of course, I would later realize it wasn't a coincidence. Federal prosecutors were conducting a RICO sting. So I discovered a RICO case because someone had been building it for years, maybe even years before I was in the court. I don't know. Nobody tells me anything. But at this time, I was just believing things at face value and trying to file my suit. And I was really thrilled when it was assigned to a Reagan appointee from DuPage County, because I knew that Judge Charles Norgal didn't have any association to the Cook County machine. He wouldn't have any reason to want to hide crimes by dirty Chicago Democrat Party judges. But what I didn't realize then is that when there's a criminal case into, for example, this racketeering conspiracy, they supersede any civil actions, and judges can make sure that civil actions don't proceed until the criminal case is resolved. I did learn that after several months of unsuccessfully trying to pursue the case, but I didn't know that then. But then something interesting happened. I found out that Judge Norgal had retired, and a couple weeks before I received the notice, my case had been assigned to a judge named Jorge Alonso. I didn't know anything about Jorge Alonso, but I thought, well, he has a Latino last name, and I just wanted to make sure there was no conflict of interest. Judge Dickler is Latino American, so I was Googling their names together to see if there were any pictures, but because I thought maybe there were members together of a Latino law organization, maybe they had a knowledge of each other. But I didn't need to work so hard, because it turns out Judge Alonso had come to the federal bench with absolutely no federal experience, which is to say wholly unqualified, after serving, wait for it, as a domestic relations judge in the Circuit Court of Cook County. In other words, Judge Dickler was his boss, and Judge Dickler probably got him the job. He was officially endorsed by Senator Dick Durbin when he was wholly unqualified, coming from the most corrupt division of the most corrupt court system in the nation. But another interesting thing happened after Alonso was assigned. For some reason, neither he nor his clerks filed a motion to have him recuse himself. And so I filed a motion to have him replaced, and it was ruled on and granted by the chief judge. It's the only motion that I've ever successfully filed and had granted in any court. And I think it's interesting that with no law experience, somehow I knew that Judge Alonso should not be my judge, but somehow he didn't know. The other interesting thing is it was within a month of Judge Alonso somehow forgetting to recuse himself from a lawsuit against Judge Dickler, who had given him his job, was his former boss, and actually at that time was also his wife's boss. His wife Diana probably still is, a domestic relations judge working in the circuit court. But after he forgot to recuse himself, shortly after, Judge Dickler abruptly retired, and there was no explanation and much speculation in the press about why she left. I think that Judge Dickler made a phone call. I think that Judge Dickler called in a favor. And I think at that time, Judge Dickler most definitely was under federal surveillance, if anybody was under federal surveillance. And I think that's why she was abruptly shifted out of the court. I can't prove that, but that's just what I think. Now, I mentioned Senator Dick Durbin here. I have no reason to believe that either Senator Dick Durbin or Congresswoman Jan Schakowsky actively participated in any crime at any point. I have no reason to believe that they conspired with any of the people named here while conducting their crimes. But I do have every reason to believe, because they do it publicly, that Senator Dick Durbin and Congresswoman Jan Schakowsky publicly put their support behind people like Grace Dickler and Michael Bender, who are criminals. And I think because they're publicly supporting criminals, particularly Senator Dick Durbin, who claims to be an expert on the judiciary, having headed the Senate Judiciary Committee, I think if he's going to go out and say that he stands behind the Chicago judiciary, he needs to explain everything, including the crimes of the Chicago judiciary. So I'm hoping at some point this case will end. I'm hoping at some point questions will be asked by people who, unlike me, matter and can get answers. And I'm hoping to understand why my life has been sacrificed to build this case, and I hope it's worth it.